Assalamu alaikum wa rahmatullahi wa barakatuh. Good evening, everyone, and welcome to a new episode of SIPA podcast, which is considered the first intellectual property podcast in the Arab world, GCC, and MENA region. And it's one of the activities of the Scientific Intellectual Property Association, SIPA. And nowadays, we are celebrating the World IP Day. And this year's theme relates to IP and music, feel the beat of IP, and it highlights how intellectual property rights protect or can protect the creations of musicians and composers and etc. All people work in the music industry. And today we will continue what we have started in our last episode related to AI and IP and all the things we have talked about. Today we'll continue with our esteemed guest, Mr. John Osha, who is the global chairman and the founder of Osha BWB International, and he has a lot of things, as we said last time. And he is a co-author and editor of a very interesting book entitled AI and Patents, and today we'll talk a little about it. And we want to make use of every minute from his time. Let us welcome our esteemed guest for today, Mr. John Osha. Welcome again with
Thanks
us.
so much. It's a pleasure to be here, and I'm particularly pleased to be invited back for a second part.
Yes, actually, the feedback that we have received for the last episode was marvelous. It's very interesting and everyone likes the episode. And today we want to continue what we have started last time.
Wonderful.
And I hope that, inshallah, everything will go okay. As you know that we have different types of audience. We have people working in the IP industry. We have people starting to study IP. So we will also consider that.
Of course.
So as a start, today we'll talk about patent in the age of AI, what the challenges we have, what opportunities we have, and talk in details about that. So at the start, you know that different books, different research give different definitions to patent, what a patent is.
Yes.
And one of the simplest definitions that I have read is that a patent is a technical solution for a technical problem. This is very simple definition. But when I thought about it, I discovered that why the problem is technical only. It can be scientific problem. It can be any type of problem. So what is your definition for what a patent is?
Well, the question that you're asking when we talk about whether something's technical or not, we're dealing with the question of whether whatever has been created is the kind of thing that we want to allow patents on. So even before we get into the question of is something new, right? And so should we be allowed to have a patent on something because we've created something new? Obviously, that's a requirement. But at the base level, we first have to decide, is this something that we want to allow patents on? And there's different words for that in different countries. But let's call it eligibility, whether the creation is eligible for patenting. And as a policy matter, governments don't want to allow patents on certain types of things, right? So, for example, there's a famous equation, E equals MC squared, right? So this is super famous Einstein equation. Do you want to allow a patent on that equation? And the answer is no. It's just a pure mathematical equation, right?
Yes.
So drawing that line between these sort of abstract things that we don't want to allow patents on and the inventions that we do want to allow patents on is actually a very difficult thing. It's a very difficult line to draw. So different lines and different definitions have developed in different countries. And this has the unfortunate effect of meaning that some things can be patented in some countries and not in others on that basis. So technical solution to a technical problem is the European definition, if you will. So they're going to look and see if what you've invented is technical in the sense that it solves a technical solution, solves a technical problem. The US definition is somewhat different. It ends up in the same place at the end of the day some of the time, but not always. So this is one of the aspects that we struggle with in some AI-related inventions.
Yes. Why I'm asking this one? Because we have different types of problems. We have medical problems, we have scientific problems, we have social problems. Why should be technical only? So it's good that you clarify this. We came to know last time that you are the editor and the co-author of a very interesting book. I'm lucky that I have a copy of it. Thank you so much for that. Which is Artificial Intelligence and Patents. This is a book, and we want you to give a small brief about the book, its background, its target, and etc.
Great, thank you very much. Well, so at that time, when it started, I was Reporter General of AIPPI. AIPPI is the International Association for the Protection of Intellectual Property. And AIPPI has an ongoing partnership with a publisher called Wolters Kluwer to do a legal book every year. And so we chose this year to focus on AI and patents.
So every year they have a book?
Every year there's a book, and it's on a completely different topic.
Yes, but by the members or by the...
It's by the members.
By the members, okay.
And the approach is always international, because that's what AIPPI is. Yes. So AIPPI will pick a topic and then look at the international perspective. And so, for example, in this case, I was the editor, which meant that I kind of came up with the theme of the book and how it would approach the topic. But then we had many, many contributors, more than 30 from different countries.
Yes, I have started reading it, and I was surprised by the number of participants and contributors.
Yes, really great minds from all around the world, who then addressed the topic from their different national perspective. Yes. And on this, which is such a new topic, AI and patents, you see very, very different approaches from different countries. And that's what I think makes the book very interesting. There's an introduction generally to the issues. There's an explanation of what AI is, which, by the way, is a good starting place. Everyone wants to talk about AI, but a lot of people don't really understand what it truly is. And then looking at these discrete issues from the perspective of different countries. It's fascinating.
Yes, but of course it was challenging for you to edit all this kind of point of views and all.
Yes, it took about 2 years actually from start to finish. So it was a challenging project to do.
Yes, different points of view and different people, different mentalities. I'm sure that it was very challenging too.
Yes.
Okay. Now we have one startup question: that how AI transformed the innovation in general and patents landscape in recent years?
Broad question.
Yes.
Let me take the first part first. So, because I think when we talk about AI and patents, it's helpful to start with the beginning. So, how has AI impacted innovation?
Yes.
Right? And if we look back years, there have been many tools that have impacted innovation, right? From things like computers, right?
Yes.
When computers went from being available only at the university to being available to all of us in our home office, that's a huge impact on innovation.
Yes,
the internet,
it was a big thing at that time. Yes.
Right.
Yes.
So these tools that have come along from time to time have all made impacts on innovation. And AI has done the same thing. So in one respect, it's another tool. And we need to keep that in mind. It's not a living, breathing human. It's another tool. But it is a different kind of tool that can make larger logical steps than other tools in the past. And it does tend to raise some interesting questions, particularly when it comes to inventorship. And the question on inventorship is often misunderstood. So I hope we take a little time to talk about it. Yes. But the question is not, is the machine inventing? That's not such an interesting question. The interesting question is the human who's using the machine inventing, right? Is the human doing enough inventive stuff?
Yes.
Right? And that's the question that we need to answer.
Yeah. One straightforward question that we discussed before, and I want you to discuss today also, that can the output of an AI machine, I use an AI machine to draft something or to invent something, can the output be patented? Why or why not?
Yes, so absolutely it can be. There's a couple of questions there. The first is going to depend on inventorship. Right? So, and we have different laws for different countries. So there's not a
Yes.
global answer.
Yeah.
Some countries care more about inventorship than others. So let's talk about the United States, because the United States is a country that cares a lot about inventorship. And if you have the wrong inventor listed on a patent, that patent can be invalidated on that basis. If you have somebody on there who was an inventor, or you're missing somebody who should have been, there's ways to fix it, but ultimately you could potentially invalidate a patent on that basis. So it's critical that we get the inventorship right. So that's the first question. If we're trying to patent something that in whole or in part was the output of an AI system, who's the inventor? So under current US Patent Office guidance, we need to have at least one human inventor who made a significant contribution to at least to every claim that's in the patent. And as long as we have that, we're okay on the inventorship issue. Then, of course, it has to be new, just like anything else. It has to be new over the prior art, and it has to be non-obvious over the prior art, just like any other patent would need to be.
Yes. This US opinion or US strategy, just now before coming to the episode, I read something published in Saudi Arabia from the Saudi IP department, discussing three things. Can be patented or not. First, the AI machine, I use an AI machine to draft something without any addition or without any editing from a human being. This cannot be considered as a patent.
Right.
But if I use it and I use my personal input, I edited, I added my points here and there, this kind of mix, it can be. So I remember in our last episode, most of the questions you said or you answered me that I cannot give you a definite answer because it's a debatable thing and there is nothing final. The only one thing that you give me definite answer is that AI machine cannot be an inventor. No, yes. We will not accept that. And you know that what happened in with the Davos case?
Of course, yes.
That this lawyer or attorney, he created one AI machine or AI tool through which he can draft a number of patents, and he applied in US, in European Union, in Australia, here and there, but all they rejected that. We cannot consider the AI machine as an inventor. It should be a human being. And there is a legal conflict. The court rejected, then the high court accepted that there is no problem that AI machine can be an inventor. Then the constitutional court rejected that. No, we will not accept that.
Yes.
So from your own point of view, will this be in the future? It can be changed, or still it will not change? That AI machine cannot in any way be an inventor or creator or writer?
Yeah, so let's be very clear what we're talking about. So
Yes.
the question in the Davis case was, can you list a machine, a non-human, on a patent application as an inventor?
Yes, exactly.
The answer is no. And the answer will always be no.
Yeah.
Okay, so I think that's very clear. Now, those cases are often misunderstood as being about whether a machine can invent, like whether AI has the capacity to invent. And we could spend hours talking about the philosophy of that question, but it doesn't matter. At the end of the day, it has been determined, and I believe correctly, that a machine cannot be listed as an inventor on a patent application because a machine cannot have rights. All right.
Yeah.
So unless our society changes and we start having machines that are citizens, and this is crazy stuff for the future. No, for now, we're not going to list a machine as a co-owner or inventor of a patent. But the role of AI in the inventive process, it can be very significant and will continue to become more significant. So we have to consider that as how we deal with the policy about inventorship. And as I mentioned, the way the U.S. Patent Office dealt with that is to say, just look at the human activity. And as long as there's significant inventive human activity for each claim in the patent, you're okay because you have a human inventor.
Yes.
And that's actually consistent with the resolution that AI PPI did on that same issue some years earlier. I think that's a good answer, but we'll see what the other jurisdictions have to do with it.
Yes, I was attending one workshop long time back, I think last year or before last year. So the speaker said, and he highlights the monkey selfie,
Yes.
the case that was in US. And he said the court rejected to consider the animal as a creator or as a photographer. So how do you allow machines? So this is also very interesting point that it will keep, I think they're trying to keep the human creativity. Because if you consider AI machine as it will be done. Khalas, human creativity will be gone. So I will ask you something from my practical thing that I'm facing here and there, that people will say, okay, the IP department, the patent department or the patent office will not consider the AI machine as an inventor. So I want to apply for the patent. So what I can do with that, I will use an AI machine. I'm just assuming something that is happening. And I will take the output, I will edit it myself, I will add my own points, I will rephrase it in somewhere or some way. Then I will not disclose that I used AI machine. I will say that I am the inventor. I am the one who drafted these specifications or claims or whatever. So from if we are talking about, or from the legal point of view or legal perspective, is this considered as fraud if you use AI machine and you did not disclose it? And from the ethical point of view, this is considered cheating? Or how you can, if this is the case, how you can evaluate it? And it's happening, by the way, it's happening. In some cases, it's happening that people will use machines to draft something, but they will not say that I use it. They will not disclose. They will say, I drafted it myself.
Yes, yes. So two separate issues, right?
Yes.
So first of all, we're talking about inventing and using AI tools to invent.
Yes.
Okay? So in that case, do I have to disclose in my patent application that I used an AI tool to make my invention? Okay? Now, the answer to that, at least in the United States and in every other jurisdiction so far that I know, the answer is no. Okay? So you do have an obligation, for example, in the US, if you know the inventorship is improper, you have an obligation to disclose that, because otherwise it would be fraudulent. So if it were truly a situation where a machine, an AI system, made an invention by itself, which I don't think has happened yet, but let's imagine that that happens, and I just put my name as the inventor on the patent application, that would be fraudulent. And that patent, if it issued, should be invalid. Okay? That is a very different situation from using an AI system to draft something. So you're right. We have a big problem with people, lawyers who are writing briefs, for example, and they use an AI machine, and there's been many examples of this. The AI machine will make false statements or will cite to fictitious cases. And the lawyer puts their signature on that.
Yes, reporters, journalists, editors, everyone is using.
Yes, yes. And I think that's a big ethical problem.
Exactly. Yes.
You could end up also plagiarizing somebody else's work without realizing, because the AI may make a copy. You certainly can get in trouble if you're a lawyer and you put your, or a journalist, you put your name on something, it turns out to be untrue. But that is a distinct issue from the question of AI inventions. And it may be helpful if you permit me to just take a moment and explain, when we're talking about AI and patents, it's super helpful to think about there being three buckets. And because it's so easy to get these issues kind of conflated. So the first bucket, the first group of AI and patents is the core technology, right? So this is the inventions that are on the technology that makes AI work, the algorithms, the systems, all the neat stuff. And so that tends to be math and software. The next bucket is the application of that technology to some particular use case. And this is where 90-something% of AI related patents
Yes.
are. So you're taking AI and you're doing something with it. You're making a computer write a paper, or you're making a car stop at a stop sign, whatever it may be. And then the third bucket is where we're claiming the output of using AI as part of the inventive process. That's like the Davis situation.
Yeah.
And it's helpful to think of those three buckets because you have three completely different sets of issues that arise. In the first bucket, it's what we started talking about, whether it's technical or not, because it's just math and software.
Yeah, exactly.
It's very hard to patent that stuff. The second bucket has a different problem called sufficiency that we haven't talked about yet. And the third bucket, the issue more or less, is inventorship, which we were just talking about. So those three buckets, so to speak, are very, very helpful for trying to explain those issues. And that's the methodology also followed in this book.
Yeah, okay. So how different jurisdictions like US, European Union, China, Japan, how they are dealing or handling the patentability of AI-related inventions? Is there any gaps between them, or they are in the same line, or?
A lot of gaps in between them. Yes,
Okay.
yes, a lot of gaps in between
In brief,
them.
can you give the differences between the jurisdictions?
Yeah, so again, we have this two-step thing we have to get over to get a patent. The first is this what we're trying to patent the kind of thing that we want to allow patents on? That's this kind of threshold question.
Yeah.
If you don't get past that, you never get to the rest of the process. And then question two is it new? Is it non-obvious? Does it have inventive step? So that first threshold, is it the kind of thing we want to allow patents on? Right now in the United States is really hard. And it's not only hard, but to be honest, it's inconsistent. So you get different results from different examiners, from different panels of the federal circuit. So it's really a bit of a mess in the US. And so that's where we get stuck in that first bucket cases, and in some of the second bucket cases too. Europe, on the other hand, it's relatively easy to get over that first threshold. But when they then examine the newness of the claim under the approach they use called the convict approach, they take out all the non-technical stuff. And non-technical would mean the math and that sort of thing. So you can end up with all of the new stuff being taken out of your claim during the analysis to see whether your claim is new, in which case, obviously, you're going to fail. Right? On the other hand, in China has issued guidelines that explicitly recognize that certain things are technical. For example, processing of big data. Because the human mind couldn't possibly go through these trillions and trillions of bytes of data. So China recognizes that inventions that achieve new things using that by processing that data is technical. So it's easier to get patents in China on these types of things than it is in Europe and the United States at the moment.
Yeah, so how can this takes us to another point, that how can the traditional patent system cope with the rapid pace and rapid developments of AI?
Well, it's going to be a process, right? We did see the same thing when the issue of software and patentability of software became a big thing. This is 25 years ago or so. There were big arguments about whether software should be patentable or whether it should just be covered by copyright. And there were many of us, including me at the time, who were arguing, look, I can implement something in a circuit and I can implement the same thing in software. Why should we be able to patent the circuit and not the software? right? And so as long as the software had a certain functionality, a certain technicalness to it, then ultimately it was found that you could patent the software, not as such usually, but as part of some system that achieves some function. But that took a while to get there, and I think we're going to see the same thing happening on the AI issue. And the offices do cooperate too. I mean, really, I'd like to commend the offices. They not only work very hard to deal with these issues internally, which are new challenges to train their examiners on this stuff, but also cooperate with the other offices for the benefit of the stakeholders internationally. And we see that in the IT3 group, which is the USPTO, EPO, and Japan Patent Office, which works on substantive patent harmonization, and the IP5 group, which adds CNIPA and KINPA, so China and Korea, which is working on more procedural harmonization issues. And both of those groups have had really good outcomes over the year, and both are looking at some of these AI-related topics.
So we have a lot of challenges, actually. So let's talk about opportunities. Talk about different angle, that the benefits of AI. Can AI machines or AI tools help the startup companies, the SMEs, in drafting their applications or in improving their IP system, IP strategy, IP policy? How can AI or how can startup companies, SMEs, make positive use of AI machines or AI in general? Especially that that AI, that startup companies, they don't have normally they don't have the in-house legal team that they can advise them or direct them. So how they can make use of that?
Well, again, I want to be very clear in separating the use of AI as part of the innovative process and the use of AI for drafting patent applications.
Yeah.
Okay? Two very separate things. So there are innumerable ways that AI systems can use SMEs, can help SMEs and startups in their business, whatever their business may be, in terms of facilitating research, reducing the head count, the number of humans that you have to pay. And it really just depends on the field of their study. On the other hand, in terms of using AI for the IP process, it's not something I would trust yet, right? Ultimately, may AI systems replace patent attorneys like me? I don't know, maybe, but not yet. And I would not recommend that anyone today rely on an AI tool to draft a patent application if that's going to be an important asset for their business, because the likelihood that it's going to be done well enough that it would stand up to stand up in a court is low at this point.
Okay. Related to that, can AI tools in general, let's look at it from a positive point of view, that it can help improving the patent system in general, like helping the patent offices in the checking the prior art or in the examination process itself, fasting the examination, because in some countries to register or to get a grant of a patent, it takes years. Mm-hmm. So can AI be used to accelerate the procedure of registration, like checking the prior art, doing the substantive examination? Can it be used like that?
Yes, absolutely. And there's some things that AI already does very well. So prior art searching is one thing, that traditionally in the old days was done by humans.
Manually.
Yeah,
yes,
manually. I mean, when I started out, I used to go and look through paper patents.
Exactly. And you can miss something.
It's easy to miss something.
Yes,
and then, of course, we had these, searchable databases, which we still have, and you use these complex kind of syntax, keyword searches, which work very well, but you have to be quite skilled to know how to search those systems. Yeah. And now you can put in a plain language search and AI does the rest for you. So that's excellent. And so, yes, that really speeds things up. At the patent offices, we also have classification that's being done, at least initially, by AI. That means when you file a patent application, the patent office has to decide which group of examiners does it go to. Does it go to the software people or the chemical people?
Technical, chemical.
and actually much more specific than that too. And so now the offices have these AI-enabled classification systems. Then, of course, in the examination, so far, there's not actual full end-to-end AI examination, and I hope there never will be. But there is pre-examination, that's going to kind of make the examiner's job easier. And so there's a lot of efficiencies there. On my side, when I'm working with a client on a patent application, I do not use an AI system to do my work, but I use AI systems to facilitate my work. And how might that be? Prior art search, absolutely. There's some very useful tools that will highlight the relevant portions of prior art references. That's not replacing my review, but it's facilitating my review. It's pointing me to where I need to read, right? And it's saving some of my time. There's, of course, grammar checking tools, that sort of thing, that are very, very helpful. There's a tool that will review the patent application at the end and make sure that like the numbers on the pictures, on the figures, match the numbers in the specification.
Yes.
Which that used to be a kind of laborious manual process that now takes a second. So there's a lot of that sort of thing that facilitates the overall process. It saves time, it makes the quality better, but it's not replacing the human judgment.
Yeah. So I can see that you are a supporter of using AI to improve the patent system. What about other industries like legal? Now people also trying to use AI tools to help lawyers or attorneys or in drafting. And the problem is that people make a lot of mistakes. They misunderstand that AI is a assisting tool. I cannot consider it as doing everything for me. I can use it as an assisting tool. Then I should have the output, edit or revise and as you said, in some cases they put wrong case numbers, and attorneys face a lot of problems there. So we can consider it as an assisting tool to help them.
I think it's a wonderful tool to assist if you understand what the answer should be. If you are in a field where you know nothing, then trusting the AI to replace the advice that you would get from a professional is generally unwise. So that it is the AI of today does a great job of automating tasks in a very amazing and intelligent way.
And from my experience, the output is based on the input. I am the user. The way you are asking the AI machine to do something, of course, it has direct relation with the output. So the user should be very careful when he's asking it.
You're exactly right.
Yeah.
So if you don't know what the right question is to ask, you're not going to get the right answer.
Yes, exactly.
And so this concerns me that people will overly rely on AI to make important decisions in their life and find that, ooh, that was bad advice, right? Well, the AI told me. Okay, sorry. So it's important. There's some things, of course, it doesn't matter that much. If you want to rely on AI to tell you, what to buy at the grocery store today, okay, there's no harm. But there are some situations where there can be harm.
I think we have another task that we should, what we call, change the mentality of the customers or the clients that we are dealing with. We have some people, some clients, for example, in legal translation field. He will bring one file like 100 page, and he wants to translate from English to Arabic. Then we will look at the file. Okay, this will take 3 days to be ready. Why 3 days? Now we have AI tools. You can put the file and it will be translated within minutes. Right. They cannot understand that we cannot trust whatever. Until now, I'm not using any AI tool for my job as a translator, as a legal translator. I'm still doing things myself manually. Because you cannot trust. You have cases with claims of millions or billions, and maybe one mistake will affect everything. So how you can see the mentality of the people, I mean, not in the industry, no, dealing with the professionals or practitioners or whatever, they think that using AI machine can solve it very fast. If I ask you something to do something for me, you can do it very fast. How we can change this mentality?
Oh, I think that's difficult. That's difficult because, of course, the people that run businesses, our clients, are interested in maximizing their budget power, and if they see what they view as an opportunity to save money and still get a good quality output, then that's a very reasonable thing to pursue. But we do have to explain that our job, or my job as a patent attorney, is to make sure that when I take on a client and agree to do a piece of work, that work is correct and is of high quality. And as of today, and I believe for the foreseeable future, there is not a complete substitute of me in any AI system. So I will use all of the AI systems I can to speed up, make my practice as efficient as possible, and to pass on that savings where it is achievable to my clients. But if somebody came in and said, "No, John, I want this done tomorrow, just use AI, it'll be fine," I'm going to send them home. I will not put my signature on it. And I think most attorneys would be in the same situation.
So you mean it requires a strong reaction from our side?
Yes.
We should be very strict. No, I cannot trust this.
Yeah, and we just have to explain, look, it's not yet.
Trying to convince them.
Yeah.
Okay.
Yeah.
This will take us to another point. You know that this year's celebration of World IP Day is, the theme is IP and music.
Yes.
Feel the IP beat. And it tries to highlight the how IP rights can protect the creations of musicians and composers and all people working in the industry. And last episode, we came to know that you started your career as a singer and you have experience in music. And you said that there's some kind of tools or websites that can create some music for you. So how now the system can deal with this kind of infringement against music? That I can go to any website, I need some music similar to Beethoven or similar to someone, and it will bring it out. So how we can deal with this situation?
Well, I hope we deal with it, and we deal with it quickly, because I think it's very, very unfair to the creators. And to be clear, it's not only musicians, it's artists and
singers,
anybody that's creating creative work, that's protected by copyright. And there's at least two ways to deal with it. First is to control the use of that copyrighted work as training data for these systems. Because obviously, if you can go in and ask a system to create a song in the style of a particular person, which I did as a demo just the other day in the style of a country music singer, American singer named Randy Travis. He has a particular, like a recognizable, very low kind of bass voice. So people, you hear his voice, you recognize it.
And you said it looks like identical to the original one.
It sounds, I asked the system to make a song and to have him sing it, and it really sounded a lot like him.
Yeah.
So in order to be able to do that, that system must have trained itself on all of his works. So if I were Randy Travis, I'd be very upset about that, right?
Exactly.
So the first thing that we do is we find a solution to this unauthorized use of copyrighted works for training data. And that's not an easy thing, because there's a balance. We want these systems to be trained, to be smart. We want them to keep getting smarter. But we also want to make sure we're not disregarding the rights of the copyright holders. The second thing that we need to do is, on the output side, is to have clear rules for when an output is an infringement, copyright infringement of an existing copyright of that owner. The tricky thing, though, with music is that new work that I created the other day in the style of Randy Travis, sorry, Randy, is probably not a copyright infringement, because it's actually probably not a derivative work of any one of his songs. But what it probably is a violation of some other neighboring rights, maybe his right to publicity and that sort of thing.
So you mean it will be difficult to take action against this violation? It will be difficult, or
strictly under copyright, yes, right, on the output, right. But there's other ways, other arguments that can be made that we're going to need to further develop. But the problem there is that those are not nearly as uniform internationally as copyright. Copyright, we have this thing called the Berne Convention that almost every country has signed, and so there's a reasonable level of harmonization on copyright law. But when it comes to the right of publicity and other related rights that might be brought to bear on that situation, it's quite varied country to country, or frankly, even within the U.S., state to state. So I might be able to sue him in California, but not sue him in Texas. And this is something that's going to require more development.
So in your opinion, what action should be taken to control this situation, that anyone can compose anything similar to other music or similar to singers? And we have in the Arab world some software that they will put the sound of some singer to sing a song for another singer, something like this, from old ages or from a long time ago. So what action should be taken to control this?
Yeah. Well, I think we're going to have a solution on the training data side. And this is something that's being discussed everywhere at the moment. In the United States right now, we have at least a dozen federal lawsuits that are currently pending on various different fact patterns, but contesting this issue of, can you use copyrighted works as training data? So I think in the U.S. we're going to develop a rule on this within the next year or two. We're going to start seeing these cases come out. Maybe we'll have a Supreme Court case. But as I said earlier, it's an issue of balance, because we want these big systems to be trained with as much information as possible, but we also want to respect the rights of the artists. I mean, we have to, because otherwise, you think of an artist who has spent their entire career getting their name known for a particular type of art. You know, if you walk into an art gallery and you see something and you say, "Oh, that's that person," right?
Yes.
I mean, that takes a lifetime to create that type of recognition. Or you hear a song, "Oh, I know who that is." That's their identity. That's their life work. And if that can now be stolen from them at a stroke of a few keys, I think that's very, very unfair.
Yeah, this is very interesting that in US they start to concentrate on the training data, because I can see in other countries they are blaming the violation, or they are discussing about the violation of the output of AI machines or AI tools.
Yeah.
But no one is talking about that who used the data to train this AI. There is infringement also here. So this also need to be changed, that we should blame first. And some people will design or create an AI tool, as you said last time, just their purpose is to imitate or copy what is existing in the past. So this also need to be changed in some countries.
Yes, indeed. Because you can have these, I would say, good faith general purpose systems, very large systems that are there for the public good and perhaps the profit of the person running them, but they're not designed to do something bad. A particular user might be able to insert a query that results in an output that's an infringement of somebody's rights. And as you and I have talked about before, I think that's then probably on that user. That's that user's problem.
Yes.
But on the other hand, if somebody puts up an AI website, the specific purpose of which is to infringe people's rights of publicity or copyright, then I think there's probably some sort of secondary contributory liability on the part of that platform. Yeah.
Okay, from the what we discuss from the ethical point of view or ethical perspective, how we can make balance between encouraging the inclusion of AI in the patent system or IP system in general, and fair competition. How we can make balance between the two? Because for sure there will be some kind of discrepancies or some kind of violation somewhere. How we can make balance between the two? Encouraging the AI inclusion in the process itself and keep the fair competition.
Fair competition between whom?
For infringing other people's rights, between the AI machine and infringing other people's rights.
I think that's a difficult question to ask in the abstract, right?
Yeah.
In terms of the input, I think we need to develop a fair system. that makes sure that the owners of copyright have agreed explicitly or implicitly under some system to the use of their data, so that it's they're much like collective licensing of music. That there's a way that they can see the benefit, and in my view, they should have the right to refuse to participate if that's their choice, right? And that's kind of the fairness aspect of it, in my view.
So if you have the choice to change something in the IP framework to better accommodate AI in the IP, what will be your choice? Change something in the current framework.
Well, the biggest thing for me would be eligibility. Business likes clear standards, so we could work. We, the patent bar, could work with almost any reasonable standard, as long as it was the same, because then we can plan. Right? If you develop an AI system in your company, and you have to make a decision: am I going to try to patent this, or am I going to keep this as a trade secret? Well, a critical decision that you have to make there is, do I think I can get a patent on this? Let's just assume that it's new. I mean, it's amazing technology. Nobody's ever done this before.
Yeah.
But is the patent office going to let me have a patent on this? Is it too abstract? Is it too mathematical? And the problem that we have right now is we don't know. And I have to tell my client, yeah, I think you can get a patent in China, probably in Japan. I don't think you can get a patent in Europe, probably not. And you definitely are not going to get one in the US. That's not very helpful, if you're trying to roll out an international product. So clarity on that would be hugely, hugely helpful.
Do you think it needs a cooperation between different jurisdictions?
I would love to see cooperation between the different
Yeah,
jurisdictions.
because we can see that everyone is thinking from their own side, US in one side, China in one side, Japan in one side, European Union is taking different direction. So it requires some kind of cooperation, I think.
Yes. And I would love to see the governments cooperate and come up with a standard that works for everyone.
A lot of challenges, a lot
yep.
of, yeah.
And in all areas, I mean, completely outside of AI, just take another example, like grace period. We have a grace period in the United States. We have a grace period in other countries, but we don't have grace period in China, and we don't have a real, if you will, grace period in Europe. And that means that innovators have to understand that there are different standards in different countries, and you can end up losing rights to an invention in one country, but not in the other. If the standard were the same everywhere, then we, on the patent bar, could educate the clients, the innovators, and say, here's the rule. And it would be much easier for them to understand, and much less likely that they would accidentally lose rights than when you have different systems in every country. So I'm a big fan of trying to harmonize systems to the extent we can.
Yes. At the end of our conversation, I need your advice to the people. A lot of people are afraid that AI will replace some jobs. And recently I studied some course, and the outcome said that it will affect the jobs in three things. It will delete some jobs will not be there. It will amend the current jobs in some way or another, and it will create new jobs. And one guy working with the human resources the department said that we have a study that in the coming 5 years, around 300 million people around the world, they will lose their job because of the inclusion of AI. That's why the European Union Parliament start to get some kind of finance support. They are collecting some amount of money to give some kind of pension to these people who lose their jobs. So what is your advice for the people who are afraid that, I will lose my job within 2-3 years because of AI? What is your advice to these people?
Well, the world is going to change, right? And so rather than being afraid of it, I would embrace it. Right? There are certainly jobs that are going to be replaced by AI if they've not already been. And those tend to be the more repetitive type jobs that can be automated by AI systems. And that's been true. That's a progression that's been true for a while with computers and robotic systems and all of that. AI is just making that go faster, and also enabling automation of tasks that previously couldn't easily be automated. So embrace it. Learn how to use AI. Sign up for that after work class. Because that's one of the nice things. I mean, so many universities are giving these, sometimes free, or not so expensive after work classes you can take online. So learn it, embrace it. And the nice thing is it will free up a lot of the more menial work that we used to have to do. I no longer have to go search through dusty paper and prior art searches, and it frees me up to do the stuff I want to do, like this discussion today.
Yes,
right?
yes.
Yeah.
Mr. John, it was my pleasure having you today for the second time. I hope we'll meet in the future in new episodes for different topics. Thank you so much for coming, for accepting my invitation. And if you have any last comment for the audience, it's my pleasure to hear it.
Well, thanks so much. If we have a moment, there is one issue on AI and patents that we didn't quite get to that I'd love to share with your audience.
Yes.
Because it's super interesting, and that is AI generated prior art. And this is becoming a problem relatively rapidly. So I wanted to just let people know it's an issue that's out there. So when we try to get a patent on something new, when we say it's new, it has to be new over what we call the prior art. And that means the stuff that was out there before, which usually is prior patents or prior publications. The patents aren't a problem, but the publications, in the old days would be some sort of scientific journal or something, that would have been written by a human. It was peer reviewed by humans. So it was very reliable.
Yeah.
Well, now we have AI generating lots of stuff that gets pushed out onto the internet. And it could be truly just AI generated. I mean, nonsense has no reliability at all.
Exactly, yes.
It could be human generated that just used a little AI cleanup, or it could be kind of half and half, right? Maybe a human made an outline and the AI wrote the paper. So the substance came from the human, but the wording came from the AI. When you look at that paper, you don't know which one of those it is. So there's real fear right now in the patent world that this publication by AI and creation of massive numbers of publications, many of which may be completely nonsensical, that this is going to kill the patent system. There's just going to be too much stuff. Examiners won't be able to get through it. It's like all the garbage that we'll have to sift through to figure out what's real. So anyway, that prior art treatment of AI generated publications, that's a mouthful, is a big issue right now that also I think we need to look at and watch.
This is another challenge that I hope they will highlight it in the future. Thank you so much for your advice. Nice to have you today. Thank you for following us for today's episode, and see you in next episode. Assalamu alaikum wa rahmatullahi wa barakatuh.